Alex here with part 4 of the My Docket series in Corazon Real Estate. As my previous videos, please take a look at part 0 if you haven't seen it yet. That's a video that contains some of the basic disclaimers and the underlying purpose of any of the My Docket series videos. Really, one thing that I will touch on is that I'm trying to provide some examples from beginning to end in chronological order of my actual, personal case against Corazon Real Estate. And this is from 2012, so it's ancient history at this point, but I still think it has some educational value. We're going into the landlord's answer and counterclaim. I'm not sure that I can recall my mindset at the time, except that what I had read in the answer and counterclaim probably didn't surprise me or catch me off guard. The landlord was probably just upset. I remember a few details that the landlord was upset that this was even in district court. He thought it should be in small claims action in justice court. And that's kind of the only thing that I can remember, but I do recall thinking that isn't a very good defense to the lawsuit, and so I was thinking it would make my job a lot easier. It really didn't, because the judge was going to get in the way of that, and it's going to lead to a Supreme Court appeal and another order reversing. But we're going to get to all that stuff later on in the series. For now, I think we should go ahead and take a look at what the landlord has filed. Okay, here we have the landlord's answer and counterclaim. He's introducing himself, also improper person. So the landlord wants to represent himself as well. This isn't going to work, and this is going to be the basis of the Supreme Court's reversal. And the reason why is because Corazon Real Estate is a business entity, and Nevada does not allow business entities to appear improper person. They have to have attorneys. We can talk more about that when we actually get to the appeal. Answering paragraph 1, he admits. Answering paragraph 2, he admits. Answering paragraph 3, he admits. Answering paragraph 4, he's admitting most of the allegations. So these are probably just the allegations as to where he lived. If you guys really want to, you can compare these responses to my complaint from part 1. But for the most part, I'm assuming that he's admitting the allegations that have to do with where I lived, where he, the corporation that he runs, and the fact that we're both in the state of Nevada, and then the move in and the move out dates and stuff like that. He's going to deny the allegations that are substantive. Let's see here. Corazon acted as agent for. Okay, so the landlord is actually, I get it. Okay, so he's identifying this Mark Goldstein as the actual landlord, and that Corazon Real Estate is just, I guess, maybe the property manager, or maybe there's like an overarching sort of organization. I don't know what to say, except that I'm assuming that this organization probably is just paid by maybe 10, 20, 30 landlords to kind of run their properties. I'm guessing, but it's not going to come up in the case. It's not going to be relevant, so I'm not going to poke more into it. And then he's admitting the allegations. He's admitting paragraph 7, and then he's admitting 8. So for the most part, there are a lot of admissions here, which I think makes this a really clean case. I'm trying to steer this case into pure questions of law. He is picking out the few, I think, that he knows will lead to liability. So he's admitting again. A lot of the allegations are admitted, and he's denying 10. So he's trying to cite something in the agreement where the tenant is agreeing that they're responsible for certain things. But the issue here is, number one, the law, I believe, says otherwise. And I'm going to say I believe just because it's been so long since I checked it. And if you write a contractual provision that's contrary to the law, at least specifically in this chapter, then the law will override the contractual agreement. But even if I'm wrong and they can make you liable for this kind of stuff, it doesn't really matter, because there's going to be a genuine issue of material fact on this denial. What I mean by that is, just because this agreement is here and I agree to it doesn't mean that it's actually true. I have a suspicion that I deny this or would have denied it later on. And so that's going to create a genuine issue of material fact, which ends up having to go to trial. If you want to learn more about why, please watch my video on the topic summary eviction, or even better, maybe I think I have a video called mid-case termination where I explain how this works. Paragraph 11, something about a no-show fee, and he's admitting that too. Paragraph 12, another admission. Paragraph 13, there's a denial here. So, I mean, I could pick through these guys, but you can see the gist of the answer. In fact, I have a video on the topic. It's called The Answer, and I explain how the answer works. But he's basically going through my allegations line by line, and he's admitting some and denying some. And it's very interesting to me. I don't remember that so many of the allegations were admitted. And I think that that is remarkable. I don't think a lot of cases end up going this way. So I'm going to go ahead and move on to the affirmative defenses if there are any. Lots of admissions, so many admissions, admit, one after the other. Let's continue. Let's get to the counter. Okay, so it looks like he didn't put any affirmative defenses, which is not good. Typically, that's something that there's typically at least a few affirmative defenses that are applicable in a case. So this landlord is representing himself and he might not know about that. If you want to, go ahead and take a look at the video. I think I have a video titled Affirmative Defenses to learn how they work and why they should have been included in the landlord's answer. Counterclaim, I think I also have a video on the topic counterclaims, or maybe reply to counterclaims, I don't know. Definitely look around for that. But basically, this is just him filing a complaint against me for certain issues. So he's alleging that he lived up to the terms, which is not really something that I'm disputing. I'm disputing that he violated the law. Because anybody can make anybody sign anything when it's an adhesion contract. And that's, discussed in the video adhesion contract. So I'll stop there. Otherwise, I'm going to turn this video into like 4 other videos that I've already covered. But let's see here. No time did they violate the lease agreement. And then he's saying that it's obvious that he's trying to be a litigious tenant who is looking for a fast way to obtain several $1,000s to which he's not entitled. This is a common claim by landlords. So I talk about how punitive damages works, and one of the, not even just by landlords, pretty much any kind of defendant who's facing punitive damages will immediately fall back on the argument that, oh, you're just trying to get rich. And in fact, that's one of the things that was talked about in the Netflix series Hot Coffee, which talks about the hot coffee that spilled. If I don't know if anyone here remembers that, but if you watch the Netflix video Hot Coffee, you'll learn that the case is actually not really what they were trying to portray it in the media as. And so that case is very interesting because there are actually very serious punitive damages issues that arose, and that particular defendant was entitled to and won a punitive damage award. But when it got out into the PR sort of circle, they played it off as a lady who was trying to get rich off spilling coffee in her lap. And so really this is just a continuation of that same sort of argument. Anyone who's facing any corporation or business entity that's facing punitive damages will almost always say that the other side is just trying to get rich quick. It's common defense. So he's trying to get attorney fees and costs even though he doesn't have an attorney yet. Okay, and then he's trying to get loss of time for work to appear at the summary eviction proceeding, which you can't do. If you want to recover something in a summary eviction proceeding, you have to recover it in that case from that judge. You can't bring this up in another lawsuit with a different judge. In Nevada, there's things that you can file, like a motion for attorney fees and costs. There are extremely strange situations where you can do something like this, and it's a really rarely used area of law. In fact, I can't even remember what the label is for it, but it's extraordinarily rare for a judge to do that. Loss of time from work, a lot of times people will see that even brought up on like Judge Judy or the People's Court. You can't recover for that. You just have to go to court and you can't get your money back for that. Sorry. Research and labor. So he's trying to charge. Can't charge for that either because you're not an attorney. So an attorney can charge for research. That's attorney fees, but a proper person litigant can't. So I forgot that he tried to get this extra money, which he's not going to get. Then we have the verification where he's indicating that all the facts alleged in this document are true and correct. And then a notary stamp. I don't know if he would have needed this. Well, I guess he does because he didn't use the declaration in lieu of affidavit. So because he didn't do that, then he actually did have to get a notary stamp and all that. Certificate of service under Rule 5 indicating this document was mailed to me. List of exhibits. Okay, this is something you don't want to do. You can do it if you want to. These are supposed to come up later in the case, not at the pleading stage. Like I mentioned, you can attach exhibits to your pleading if you really want to. It's not recommended. Lawyers rarely do it. There are only a few teeny tiny exceptions where the law specifically mandates that you attach a very specific thing. For example, medical malpractice lawsuits, you have to have like an affidavit from a doctor or something. That's the only thing that gets attached to it. Sometimes they file it concurrently. In any event, if somebody does attach exhibits to the pleading, that does allow the other side to use those exhibits against them to try and get the pleading, to try and get early case termination principles to apply. If you want to learn more, please watch my video on the topic early case termination. So I get it that he's representing himself and so he wants to provide all the evidence now. This is a common thing that people who don't know how the litigation process works will do, but I just wanted to let you guys know that this is not typically something an attorney would do. Because he's not an attorney, I get why he's trying to do it. He wants to just show all the proof right up front, which he can do. And I'm going to go ahead and go through these. I think they may give a little bit of context to the case. Let's see. These are not legal documents, so I'm not going to spend a lot of time on them. Like, see, for example, this is a lease. Everybody who's rented signs one of these. They know what these look like. If you want to, you can go down in the description below, download this for yourself. Click on the link, download it for yourself. And then, of course, if something jumps out at you, feel free to take a look at it. But my case against this landlord isn't really about the terms of the lease. It's about a violation of a statute. So he's trying to say that because the lease said certain things, he should win. And I'm trying to say in my complaint, there actually are specific statutes that the legislature has passed that specifically state how certain things are supposed to work. So my case is built on those statutes, not on the lease itself. Otherwise, I would spend more time on the lease. But again, guys, you can go ahead on your own and download this for yourself. Take a look. If there's something that jumps out at you that you want me to talk about, just mention it down in the comments. But my case isn't based on the contract itself. Exhibit 2. So this looks like the letter. Yeah, so this is me just giving him notice of the essential services that have failed and of the requirement to maintain, which is, okay, so in Nevada at the time, there's two different categories for relief for a tenant. One is for essential services and one is for everything else. And essential services, they have to fix within 48 hours and everything else they can do within 14 days. And there's different rules to how these work, but not really the topic of this particular video, so I'm going to move on. Tenants move in and out list. So this is just a checklist, move in out, move out checklist. Not a legal document. Anyone who's rented has seen it. If you're curious, feel free to take a look. Exhibit 3, I'm just emailing about what's not working. Let's see. What is this? Oh, a work order. Okay. And then here's, what is this? Like another, I guess, one of those slips. So I'm talking about the AC, which is blowing air but not cold air. Another work order. Let's see. Exhibit 5. Bill reimbursement. So yeah, they're trying to make me have to pay these costs. So we've got another work slip. We've got Exhibit 6, residence rules. So just more rules. Exhibit 7, another work order. Exhibit 8, more issues with the apartment. Another invoice. Rule 5 certificate of service indicating this stock. Oh wait, okay, this is what I sent to him. Exhibit 9. Looks like another work order. Exhibit 10. Woodburn and Wedge. Oh, okay, so this must have been sent to the resident agent. Right, okay, so we already went this, I'm going to skip that. Okay, I already went over this, so I'll skip that. A check. Probably to block the early eviction. Exhibit 13. Payment enclosed. Not sure what that's about. Okay, oh, this is payment enclosed for the lockout, but a lockout never occurred. So maybe he's just trying to get this money back or something. Because this actually never occurred. I did move out. Next we have the notice of change of address. Okay, you guys have seen this before. Please watch my video on the topic notice of change of address. This is a very important paper that you're supposed to file when you move. And I'm not going to talk about it because I've talked about it so many times and I have a separate video on it. Rule 5 certificate of service indicating this document was mailed to the opponent. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. The Corazon real estate filed an answer and counterclaim. If I remember correctly, it's around $300. I'm not going to go and track down the exact dollar amount. This is really just, the aftermath is really just about kind of ballpark figures. So I'm going to go ahead and put down $300 in costs for Corazon real estate. I didn't have an attorney, so I incurred $0 in attorney fees. The attorney would eventually have to review the filing, and the notice of change of address I'm going to say is negligible, but the answer and counterclaim, it's pretty lengthy. All those documents that were provided, they would probably be interested to know what I had now had access to. So I wouldn't be surprised if they spent a full hour going over that particular answer and counterclaim. So at the rate of $250 an hour, that's going to come to $250 in attorney fees for Corazon real estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.